And I leaned down and whispered to him. I said, Mickey, you can't eat there because you are a little Negro boy. I said, well, it's a law that you can't eat there. And very loudly he said, well, who made that old mean law?
Imagine being denied service at a restaurant and being arrested simply because of the company you keep. This was the reality faced by Sandra Adickes, a white schoolteacher from New York that volunteered during the summer of 1964 to teach black students in Mississippi. Alongside 6 of her students, she found herself at the center of a civil rights case. This video is about Adickes versus Kress, a legal battle that challenged de facto racial segregation in the South. The case set a legal precedent that private entities could be held liable under Section 1983 if they conspired with state actors to deprive individuals of their constitutional rights. Join us as we explore the historical context, legal arguments, and lasting impact of this fight for justice.
Well, I'm not about to sacrifice my children. I mean, I want them to get a good education, but I really believe they can't get a good education in an integrated school. At least not in the South. It just won't work in the South.
While the decision in the case Brown versus Board of Education, nearly a decade earlier, affirmed the unconstitutionality of segregation, the actual execution of the decree left much to be desired. The lower courts were ordered to require defendants, typically school boards and state officials, to begin desegregating public schools without providing a clear timeline or mandate for its immediate abolition. This directive shifted the responsibility for initiating desegregation onto those who had been accused of maintaining it. In light of this, the National Association for the Advancement of Colored People, or NAACP, which led the Brown case, encouraged parents statewide to file desegregation petitions with school boards. However, their efforts met fierce resistance from the newly formed White Citizens Council. Composed of Mississippi businessmen, the council retaliated aggressively against the petitions. They publicly identified petitioners through newspaper advertisements and store window placards, subjecting them to scrutiny. Those working for segregationist employers often lost their jobs, and black businessmen faced economic reprisals as distributors refused deliveries, banks denied credit and loans, and white clients boycotted their businesses.
This entire integration movement is based on false legal grounds. The grounds being the so-called Supreme Court school integration decision of May 17, 1954. In the Stell case in Savannah, Georgia, which was decided recently, uncontradicted, unrefuted testimony showed that the factual basis of the Supreme Court decision was entirely wrong.
Amidst the ongoing resistance to integration, prominent civil rights organizations proposed the creation of Freedom Schools, a 6-week education program, as part of their summer project. The initiative was fueled by more than 1,000 volunteers, most of them white college students, but their ranks also included doctors, lawyers, and clergy. Their aim was to address educational disparities and empower black youth to express their concerns and aspirations. It should be emphasized that volunteering for these schools was dangerous due to the violent opposition from white supremacists and local authorities. As Reverend Ed King described in his book, Behind the Scenes of Freedom School, quote, "The students who came down to Mississippi in 1964 knew they were doing something romantic, dramatic, and different, but that certainly wasn't their only motivation. They also had to face the fact that they might be jailed or could be beaten because that sort of thing had happened with the Freedom Riders in 1961. By 1964, they knew, of course, that Medgar Evers had been killed in Mississippi. Several other people were murdered through the winter while we were building up to Freedom Summer. They had all heard about the Birmingham church bombing, where even children were targets. We were actually screening the volunteers and refused a few people who we did not think were prepared for the conditions in the state. Despite the adverse conditions, Adickes resolved to join the effort in Mississippi.
For years, I've been saying to students that the best thing one can do when one is young is to become involved with a movement dedicated to making life better for others.
In the summer of 1964, Adickes arrived by bus in Palmer's Crossing, a close-knit suburb of Hattiesburg, Mississippi, to teach at the Priest Creek Baptist Church Freedom School. There, she found a community of students enthusiastic to learn about their heritage and take part in the freedom movement. Sandy, as she was called by the students, engaged in discussions, essay writing, historical reenactments, and political debates. Despite challenges, such as being denied library access due to segregationist policies, the students thrived, empowered by their newfound knowledge and determination to effect change in their society. Many went on to attend college, becoming catalysts for integration and advocates for civil rights in Mississippi. During the final weeks of Freedom School, students were eager to act under the newly enacted Civil Rights Act of 1964. Despite policy against confrontational actions, the students were determined to make a stand. They would go to the Hattiesburg Public Library to request library cards, a seemingly mundane act with profound implications. The group, composed by Curtis Duckworth, Gwendolyn Merritt, Carolyn and Diane Moncure, Lavon Reed, Jamela Stokes, and Sandy, boarded the bus to Hattiesburg. As they entered the library, they were met with immediate hostility. When the students requested library cards, the young woman at the reception desk stammered something about cards not being issued and called for her supervisor, Mrs. Tracy. Mrs. Tracy arrived and began a lengthy, condescending explanation. She identified herself as a Northerner with conflicting sympathies and referenced a long-standing custom upheld by the local council that prohibited integration of the library. The students listened patiently, their calm demeanor in stark contrast to Mrs. Tracy's increasingly patronizing remarks. She advised them to close their mouths and open their minds, insinuated they didn't truly want to use the library, and warned that she would call the police and close the library if they didn't leave. Impressed by their dignity and resolve, Sandy remained silent, allowing the students to lead the encounter. When Mrs. Tracy followed through on her threat to call the police, Sandy asked the students what they wanted to do. They chose to stay and settled into soft chairs to read newspapers. Within 20 minutes, the police chief arrived and, under orders from the mayor, declared the library closed. The group and the few other patrons left, and as they walked down Main Street, they discussed their plans for lunch. Woolworth's lunch counter was too crowded, so they moved on to the Kress store, where they faced further discrimination. The waitress took the students' orders, but refused to serve Sandy, telling her that, quote, "We have to serve the colored, but we're not serving the whites who come in with them," unquote. Sandy responded that denying service based on her race was against the law, as the Civil Rights Act of 1964, signed approximately a month before by President Lyndon Johnson, prohibited any form of racial discrimination, even by private businesses. Despite this, the waitress insisted and clarified that she was following her manager's orders. In solidarity with Sandy, the students announced they wouldn't eat if she wasn't served. The group left the restaurant only to be confronted by a police officer who arrested Sandy on a flimsy vagrancy charge, clearly intended to remove her from the scene. At the police station, Sandy was processed and placed in a cell. The conditions were deplorable, but bail was posted within an hour. Eleanor Jackson Peel, a volunteer lawyer, arrived with her husband to take statements and provide legal support, helping move the case to court. Vagrancy laws in the 60s criminalized individuals deemed idle, homeless, or without visible means of support, and were used by authorities to control undesirable populations, including civil rights protesters. Due to legal and constitutional changes, these laws have largely been eliminated or reformed today, though some jurisdictions now target behaviors like loitering and panhandling. After her arrest, Sandy sought to move her vagrancy prosecution to federal court, arguing that the charges of vagrancy were made in retaliation for her civil rights activities. Initially, the district court sent the case back to state court, but this decision was reversed on appeal. The appellate court found no legitimate basis for the charges and concluded they were retaliatory, with a judge stating they were, quote, "an unsophisticated subterfuge," unquote.
But I received a glorious freedom.
Sandy sought damages for the violation of her rights not to be discriminated against on the basis of race under the Equal Protection Clause of the 14th Amendment. The complaint was structured into 2 counts, both invoking 42 U.S. Code, Section 1983, which allows individuals to seek remedies when their rights have been infringed upon by persons acting under the authority of state law. The first count alleged that Sandy had been refused service because she was white in the company of blacks, under which she intended to prove that the denial was based on a custom of the community to segregate races in public eating places. The second count claimed that the refusal of service and her arrest were the result of a conspiracy between Kress and the police. She alleged that the police officer who arrested her, Officer Hillman, was present in the store at the time she was denied service. 3 years later, The case was set to be argued before a jury in New York. The courtroom was charged with anticipation as Jamela traveled up from Hattiesburg, and Carolyn and Diane Moncure journeyed from New Orleans, all ready to give their testimonies. Kress contended that uncontested facts proved no conspiracy existed between any employee and the police. They pointed to the deposition of the store manager, Mr. Powell, who stated that he had not communicated with the police and had instructed the food counter supervisor to refuse service out of fear of a riot by customers upset by a racially mixed group eating together. In his own words, quote, "They came into the door and people coming in stopped to look. Then they went on to the booths. Almost immediately there, people began to mill around the store and started coming over towards the lunch counter. The people had real sour looks on their faces. Nobody was joking or being corny or carrying on. They looked like a frightened mob. They really did, and it looked really bad to me. It looked like one person could have yelled, 'Let's get them,' which has happened before, and caused this group to turn into a mob. Quickly, I just made up my mind to avoid the riot, protect the people that were in the store, and my employees. I just knew that something was going to break loose there." Unquote. Kress also cited affidavits from the Hattiesburg chief of police and the two arresting officers, asserting that store manager Powell had not requested Sandy's arrest. The affidavit of Officer Hillman stated, quote, "This arrest was made on the public streets of Hattiesburg, Mississippi, and was an officer's discretion arrest. I had not consulted with Mr. Powell, manager of Kress in Hattiesburg, and did not know his name until this date. No one at the Kress store asked that the arrest be made, and I did not consult with anyone prior to the arrest." Kress pointed to the statements in Sandy's own deposition that she had no knowledge of any communication between any Kress employee and members of the Hattiesburg police, and was relying on circumstantial evidence to support her contention that there was an arrangement between Kress and the police. When asked whether she saw any policemen in the store up to the time of the refusal of service, Sandy answered, quote, "My back was to the door, but one of my students saw a policeman come in." Unquote. The student was Carolyn Moncure. She testified that after the group had sat down and while they were still waiting for service, she saw a policeman come in the store. Quote, "He came in the store. My face was facing the front of the store. He came in the store and he passed and stopped right at the end of our booth, stood up, looked around and smiled, and went to the back of the store. He came right back and left." Unquote. This testimony was corroborated by that of Diane Moncure, Carolyn's sister. She testified that while the group was waiting for service, a policeman entered the store, stood for a while looking at the group, and then walked to the back of the store. During discovery, a phase where each party involved gathers evidence and information from the other party, Kress provided an unsworn statement by a girl at checkout. She said she had seen Patrolman Hillman come into the store while the group was there, that he had traded a greeting with her, and then walked past her counter toward the back of the store. She continued, quote, "A few minutes later, Patrolman Hillman left our store just slightly ahead of a group composed of several blacks, accompanied by a white woman. As Hillman stepped onto the sidewalk outside our store, the police car pulled across the street, and Patrolman Hillman escorted the white woman away from the blacks and into the police car." Sandy argued that although she had no knowledge of an agreement between Kress and the police, the sequence of events created a substantial enough possibility of a conspiracy to allow her to proceed to trial, especially given the fact that non-circumstantial evidence of the conspiracy could only come from adverse witnesses. When asked if she knew about specific instances where white persons in the company of blacks were discriminated against, Sandy stated that she could think of about 3 instances. She mentioned that an integrated group was turned away from a white church in Hattiesburg, recounted witnessing a white rabbi being beaten because he was in the company of blacks, and lastly, she noted another incident where an integrated group was denied service at a drugstore in Hattiesburg. Despite her lawyer's best arguments, the trial turned out to be brief. The district court ruled that in order to obtain a favorable judgment under the first count, Sandy would have to prove a specific custom or pattern of refusing service to whites who were in the company of blacks, that was enforced by the state under its criminal trespass statute. The court directed a verdict in favor of Kress on this count because they concluded that Sandy failed to prove the discriminatory custom happened in others' instances. The second count was dismissed before going to trial by a summary judgment in favor of Kress. A summary judgment is a legal ruling that resolves the case without the necessity of a full trial. This ruling is based on the court's determination that there are no genuine issues of material fact, meaning there are no factual disputes between the parties that are critical to deciding the outcome of the case. The court found that Sandy failed to allege any facts from which a conspiracy might be inferred. The Court of Appeals affirmed the decisions. Despite the defeat, Freedom School alumni moved forward with their lives, each making their mark in a changing Hattiesburg. By 1970, Sandy's legal battle against Kress had reached the Supreme Court, resulting in a favorable ruling that overturned the earlier judgment. The court disagreed with the dismissal of the claim of conspiracy by summary judgment, emphasizing that in a lawsuit alleging conspiracy, summary judgment cannot be granted unless the party opposing the motion fails to demonstrate that there are no actual disputes over key facts in the case. The court found that, quote, our own scrutiny of the factual allegations of petitioner's complaint, as well as the material found in the affidavits and depositions presented by Kress to the district court, convinces us that summary judgment was improper here. Unquote. The court believed Kress did not eliminate the possibility that a policeman was in the store. Although the store manager claimed he had not seen policemen, the Kress didn't provide affidavits from the supervisor or the waitress who refused service, both of whom could have seen and communicated with a policeman. Also, the arresting officers did not provide affidavits, eliminating the possibility that they were in the store or communicated their disapproval to a Kress employee, influencing the refusal of service. These gaps in the evidence meant Kress failed to show that no policeman was in the store. If a policeman was present, a jury could infer an agreement between the policeman and a Kress employee to refuse service. Since on summary judgment, inferences from the underlying facts must be viewed in favor of the party opposing the motion, in this case, Sandy, Kress's failure to prove no policeman was present required a reversal. Secondly, the Supreme Court criticized the lower courts for narrowly interpreting what constitutes a state-enforced custom. It emphasized that such customs could arise from long-standing practices enforced by state actors, not necessarily from specific state statutes. The court reaffirmed that while the 14th Amendment clearly prohibits states from engaging in racial discrimination, it does not restrict private individuals from discriminatory actions in their personal affairs, unless those actions are influenced or compelled by state involvement. Although the court had not explicitly ruled on the implicit requirement for state action in this specific case, it noted precedents suggesting that states can be held accountable for discriminatory acts committed by private parties when state law or actors compelled such acts. The broader context included how state enforcement or tolerance of such customs, even indirectly, contributed to discriminatory practices. Thus, the case hinged on proving that the restaurant's refusal to serve the petitioner was due to a general state-enforced custom of racial segregation in public places. A judge also stated that Sandy could not possibly prove that Kress had a custom of serving only black persons in a mixed party, because it was only after the Civil Rights Act of 1964 became law that blacks had an opportunity to be served in Mississippi's so-called white restaurants at all. In face of the favorable decision of the Supreme Court, Sandy opted to settle rather than prolong litigation. She directed her share of the settlement, after expenses, to the Southern Conference Educational Fund. Under the guidance of Ella Baker, these funds were dedicated to supporting the education of Vernon Dahmer's children, a prominent civil rights activist in Mississippi and president of the Forest County chapter of the NAACP, killed in 1966 when his home was firebombed by the Ku Klux Klan. In 1973, Sandy embraced parenthood by adopting Dolores, a 6-year-old black girl. Sandy brought Dolores with her when she returned to Hattiesburg in 1980. Residents marveled at the transformation of their town. Old shacks had been replaced by new homes, dusty dirt roads were now paved, and significant economic improvements had taken hold, albeit with lingering disparities between white and black residents. During their stay, Sandy proudly showed Dolores the integrated library, now a thriving hub of community engagement. The old jail where Sandy had once been detained was gone. Through regular updates from a friend, Sandy learned of the ongoing advancements and the collective pride in their hard-won achievements. One conversation resonated deeply with Sandy. Used to be, her friend had reminisced, that the white man got the job. But now if you got the skills, you got the job. This simple declaration encapsulated the profound shift in Hattiesburg's social and economic landscape. The town had evolved from a place where opportunities were largely dictated by race to one where merit and ability increasingly determined success. It was a testament to the transformative power of education and the perseverance of the community in overcoming historical injustices.